Okay, so we're going to start the training. You'll want to make sure that you turn off all your cell phones and remove all distractions from your environment. So close all those other tabs because we're going to be covering a lot of material very quickly. And you'll want to make sure that you catch it all. I'm Chris Paradise. I'm a U.S. registered patent attorney and Florida Bar certified intellectual property attorney. So I'm going to cover intellectual property not from an attorney's perspective, but from an innovative or creative business owner's perspective, because you are the ones that benefit from having a barrier of protection around your intangible property. So I'm going to discuss first what the differences are between intangible property and intellectual property, because it's very different to know that difference. And then we're going to talk a little bit about the 50,000 foot overview of intangible property and intellectual property and how they work together. That's something that I've called the Concertina Principle. And then we're going to get into specifics on each kind of intellectual property. And I'm going to do all of this in about half an hour so that we have a half an hour or so for discussion with your questions. So when I'm done presenting, have your questions ready, because we will go on, I'll go on the hot seat and you will be able to ask all of your questions and I will answer as many as I have time for in the next half an hour. So let's get started right away. What is intangible property? Intangible property makes up more than 80% of the value of a company if you're an innovative or creative company, or it should. Now, some companies, some busy business owners neglect their intangible property, so they don't capture it and they don't use it in a way that helps it to grow in value and scale in value. And that's what IP scaling is all about. It's intangible property scaling the value, exponentially increasing that value. And you might, if it's going to be worth more than 80% of your company, you might want to know what it is. And many business owners don't know what their intangible property is. So I'll give some examples. So intangible property could be creative works that are created for your business or that you use in your marketing of your business. It could be your branding, how you present your company to the outside world, to your customers and potential customers, and how they perceive your company, what they remember about your company. Everything that your customers remember about your company, its products, you, any services that you offer, that is your company's brand. Whether or not you control that is another issue. But if you don't control and use the correct tools to build the value in that brand, you're missing out, because there are all kinds of good examples of brands that are worth more than $100 billion these days, from Apple and Google and Microsoft, Facebook. Those brands are valued at tens or hundreds of billions of dollars. And if they can grow the value of their brand to tens or hundreds of billions of dollars, you may very well be able to grow your brand to that level eventually. Or even if your brand is only worth millions of dollars, do you really want to leave that on the table? Do you really not want to scale the value of your brand and make sure that your business owns it and controls it? Yes, you do. And then there's other things, many other things, inventions that you exclusively have possession of or own, innovations, know-how, training, SOPs, important agreements, especially the exclusive ones where you have access to a particular vendor and only you, or you have access to a particular source of products or raw materials and only you and only your company. That has value, right? That has value that you can assign a value to if you take reasonable measures to protect it. So for something like that kind of an agreement, you'd want to have a written agreement that was hard to break, that had penalties for the other side of that agreement if they breach that agreement. And if you don't have that, then it diminishes the value of that intangible property. So why don't I call that intangible property? Why don't I just call it intellectual property? Because those kinds of agreements aren't intellectual property, right? Intellectual property are trademarks, patents, copyright, registered copyrights, and trade secrets. And if you do things correctly, some of your intangible property can be protected by your intellectual property. You can use the intellectual property to build a hedge of protection around your intangible property, but it's not the same thing because intellectual property costs your company money, but intangible property adds value to your company. You want to make sure that you own all of your intangible property, every last little bit of that intangible property should be owned by your company, because if your company doesn't own it, then somebody else does. And that can be a recipe for disaster. I've seen it before where maybe the original founders walk away with a good portion of the intangible property that they should have brought and should have put into the company. And then whoever owns that and tries to control that company later has to fight head to head with those founders. The same exact thing happened with Facebook. So we just use that as an example of something that has more than $100 billion in brand value. Well, there was a question about who owned the original intangible property for Facebook, whether Zuckerberg was the owner of that and had control over that, or whether the Winklevoss twins, which originally tried to contract with Zuckerberg to build a system similar to Facebook, or they claim it was similar to Facebook, whether they owned it. And eventually they sued Facebook, and that lawsuit was settled for millions of dollars. Zuckerberg just wrote them a check because he was doing an IPO and he needed Facebook to take off, and it was worth billions to him. And at that point, he just wrote the Winklevoss twins a check and settled it after some depositions were taken and probably millions of dollars were spent in legal fees too. You don't want to have to do that, right? The best time to think about your intangible property and to make sure you own that intangible property is when it's created for your business. So the best time to think about intellectual property, to think about the Concertina Principle, is before you launch your business. The next best time is right now, right? Don't put this off. This is something that can cost you a lot more later than it does to do it right now. So that's what the Concertina Principle is about. That's what I'm trying to do. I'm trying to reach creative and innovative business owners before they waste tens of thousands of dollars, or they lose their intangible property rights, or they get sued by somebody else like the Winklevoss twins or whoever it might be out there. It might be a competitor. It might be a much larger competitor that sues you because you're close to infringing on their brand or their intellectual property. And that would be a shame. So in order to avoid that, I'm doing these live trainings. What do you do if someone is going to try and steal or infringe upon your intellectual property later on? So it's several layers, and I kind of have to move fast through it. So I will answer your questions as soon as I get done, but I want to go through everything during the next few minutes. Just so you have a framework, you have that 50,000 foot view and kind of the detailed view of how you would use it to build that value. So the idea with the Concertina Principle is that throughout warfare, I'm a West Point graduate. and I was in the Army. And it's really easy to see when you're studying military history that the army that controls the key terrain, in the old days, that was the high ground or the pass. The army that controls that key terrain usually wins. If they can control it and keep control over it, they'll win the battle. Now, how does that relate to intellectual property at all? Here's the thing. One of the things you can do to build a hasty perimeter when you're setting up a perimeter for maybe your headquarters is you can stretch concertina wire around that headquarters very quickly. It's an advancement over barbed wire because it's quick and efficient and low cost. So a few soldiers can get out there and they can stretch concertina wire, which is a coil of wire that has razor sharp barbs on it that'll snag uniforms and tear at somebody's flesh if they try and force their way through it. And that barrier slows down an enemy that's trying to penetrate the perimeter so that the defenders can recognize the threat and respond to it. And your key intangible property and your key intellectual property that you use to string around that key intangible property are like the high ground and the barrier that goes around. So what I want to do is, thanks for joining. The people that are joining now, I hear you ding, ding, ding in. I want to make sure that you can build that hedge of protection around your intangible property. That first of all, you can recognize what your intangible property is so that you can make sure that your company owns it. And then you know how to build that that intellectual property barrier around that intangible property. So we're going to go through and I'm going to explain it from the viewpoint of the Concertina Principle, which is we're going to identify key intangible property, which means it's a subset of all intangible property. If you take all intangible property, which you should own all of it, and then you determine which is your key intangible property, you want to make sure you build that barrier around your key intangible property because that's your high ground. That's your key intangible property or key terrain. So let's talk about that. And I'll use examples because it's the best way for the innovative and creative business owner to understand what I'm talking about. This is not intended for an intellectual property attorney. This is intended for you so that you can understand exactly what your key intangible property is. So first of all, what is your intangible property? What do you need to do to own that intangible property? So in order to own creative works, your company doesn't own creative works unless it falls under a few different categories. For creative works, you have to either have a written agreement of some kind, or you have to prove that it was created by an employee during the time that they were an employee within the scope of that employee's duties and responsibilities or the scope of their employment. So let's break that down. What does it mean to be an employee? Well, under copyright law, it has to be sort of the federal idea of an employee, federal common law idea of an employee. And that's hard to explain because it's multifactored. It looks at whether, how much control you have over the person, whether they're using your equipment, whether you're paying them and you have the right to control what they're doing, and lots of different factors. So you have to look at all those different factors, and you as the creative or innovative business owner are going to have to pull out documents to prove that that person was employed during the time that that was developed. So first of all, you have to determine when was it developed, right? When was it created, that creative work? And then if you can prove that it was created during the time that they were employed by all those factors, then you have to determine that it was within the scope of their employment. So you have to have some kind of employment agreement, or, emails going back and forth to explain what their scope of employment was, what they were being paid for on a daily basis. If it was a one-off, let's say you have a administrative assistant who decides she's going to, she's also a camera buff. She's going to take photographs of all of your employees and you're going to post them on your website. Well, guess what? Taking photographs was probably not within the scope of employment of an administrative assistant, or at least you're going to have a hard time proving it. So guess who owns those photographs? It's not the person whose photograph was taken. It's not you or your company. It's your administrative assistant. If that administrative assistant gets fired 3 months down the road and decides to sue you for copyright infringement, there's a good chance that administrative assistant will win, even if the administrative assistant doesn't win because there's some implied license. That implied license is going to be narrow, and your business isn't going to be able to use those photographs for anything except for what they were intended for at the time that the employee took that photograph, outside of their scope of employment. So what would you have to do to prove that they were within the scope of their employment? You need an agreement of some kind. So regardless of how your business gets ownership of that creative work, you probably should have an agreement of some kind. That's the bottom line. And the agreement you should have is a work made for hire agreement. That's the best agreement. And it should say, I'm an employee working within the scope of my employment within that agreement. If they're not working within the scope of their employment, then it should say it's a work made for hire falling under one of the other reasons that you can have a work made for hire. And those other reasons are so that you can have a collaborative work, you can have, it's listed in the Copyright Act, and you have to specifically choose the ones that are listed in the Copyright Act. And you have to show that, yes, it was done for that particular reason, right? It was a collaborative work. If it's not, then your company can't be the, so that means that you need to be able to specify under what category that work made for hire was done for. It has to be signed, the work made for hire agreement has to be signed before the person starts work on that creative work, on the work of creative expression. And it has to be in writing. So if it's not that, then that same agreement should have a default provision where it makes it an assignment, because that's another way of transferring rights, is by assignment. It's another type of agreement, but you can have assignment provisions within a work made for hire agreement as a fall through. It's like sifting sand. And if it gets through the first sieve, it maybe gets caught in the next sieve. If it doesn't get caught in the next sieve, it gets caught in the last sieve. And what is the last sieve? The last sieve would be a license agreement. So you have the work made for hire agreement. If it gets through that, you catch it with the assignment. If it gets through that, you catch it with a license agreement. So let's talk about the next kind of intangible property, which is your brand. Also very, very important. All companies have a brand, whether they know it or not. And copyright, which we were talking about creative works, copyright can build that hedge of protection for creative works. Copyright registrations can also build a protection for your brand, because a lot of times if someone's trying to duplicate your brand, they'll also steal your creative works, your marketing copy or your photographs, or take a website and duplicate it on their site and try and make it look the same. So they may be very well copying off your website, or they might just make screenshot copies of your website in order to start building their own website. That would be infringement, as long as you say in your terms of service that they're not entitled to copy from your website. Then that would be clearly, they would be violating your copyright to copy from your website and then to use that to set up their own website. So that can protect your brand. What else protects a brand? Registering your trademark is also a way of stringing another layer, another boundary, another concertina wire strand around your perimeter, your key IP. So that trademark registration keeps someone from using anything similar to your trademark brand names, logos, slogans, anything that would be likely to cause confusion with your registered trademarks. And you can have more than one strand of registered trademarks, right? You can have one for your company brand name, one for a product brand name, one for a slogan, one for your logo, your company logo. And all of those strands together starts building up that hedge of protection around your intangible property, in this case, your brand. What other things? We said all those other things like know-how and inventions and innovations and SOPs. Those kinds of things can be protected by agreement, right? So the whole category of other stuff can be protected by agreement, at least in the short term. At least in the short term before you start selling products or services that someone can start reverse engineering. Up until that point, you can protect all of those using trade secret law. And what is trade secret law? Trade secret law is both state and federal law have trade secret protections in them. And the federal trade secret law is relatively new, and there's specific things you need to do in your employment agreements and in your consulting agreements and in your shareholder agreements just to make sure that you can enforce it against people that might be coming out from your company and going to another company or starting their own company. And if you do that, if you take reasonable measures to protect your trade secrets, then you can sue someone if they misappropriate your trade secrets. So what is misappropriation? If they out and out steal it, right? They come in and they steal it from your office. If they penetrate your internet security, your firewall, and they steal it off your servers, or if they're an employee and they're under a non-disclosure agreement and they walk away. Okay. So that's another reason why. It's another one of those coils of wire around the key IP that you have. Because for a lot of companies, the key IP is trade secrets. And if you need it, if you really need it, then there's patents, right? You can file a patent. It's the most expensive way of moving forward, but you can file a patent, you can get an issued patent, and that builds a barrier around your patentable inventions, which are a subset of things that potentially could be trade secrets. Now, some inventions can't be protected as a trade secret. So deciding if they're easily reverse engineered or if they're reverse engineerable at a reasonable cost to your competitor, then if it is, and you need that barrier around it, if it is your key invention, then you need to invest in patents. You need to invest in more than one patent. You probably need a series of patents to protect that invention in order to have enough rolls of concertina wire spread around your key invention that you're not going to be, no one's going to be able to steal that without having a very good defense against them doing the same thing that you're doing. So that covers, I see I'm just about out of time. That covers everything that I wanted to talk about briefly. I want to take a couple of more minutes to talk about what you can do to actually protect things if someone tries to start infringing. If they try and get through that barrier that you've now built around your key intangible property. Let's go through it in order. So copyright. If someone infringes a copyright that you have a copyright registration for, then you can very easily take, if they post it to a public website or they post it to social media, you can very easily take down their website or their social media site because you have a copyright registration. You can also send them a demand letter and say they have to pay you a license for the period of time that they misappropriated your copyrighted material. Or you can get recurring revenue even from licensing it to them beyond the point when you were going to stop them from using it. So in that way, potentially you could have other people paying you passive income, and they could be using your creative works or creative works that were developed for your company. So that's really two sides of the coin. One, you can stop them. The other, you can license them to continue using it, but at a cost. Both of those give your company an advantage, right? If they're paying you what you would be making as profit, then that reduces the work that you have to do. If they're stopped from using it and you're the only company that can use it, then potentially you have a commercial advantage if that really is key creative works. Your key creative works should be the ones that your customers highly value, or that another company you value because another company can't use it. What about trademarks? Well, it turns out that for a large number of social media companies and even internet service providers, they will take down somebody's website even if they're infringing your registered trademark. For example, Amazon, Amazon.com, which sells about a third of all products now in the US, they will take down somebody's products if they're infringing your registered trademark. So that is very powerful. It doesn't cost you. It only costs you to have someone that spends their time going out and doing that. It doesn't cost a lot of money is what I'm saying. It doesn't cost attorney's fees. You don't have to have an attorney do that. You can have someone trained in your company that would go out and do that. They just have to go through the rules that Amazon has and be persistent, and they will eventually take it down. The same thing for places like Facebook, Facebook Marketplace, most of the social media sites that are out there that are being used for marketing these days. If someone is infringing your brand and you have a registered trademark and they're infringing that registered trademark, you can take down their social media site. And that will start your negotiation with them, right? Potentially they'll stop right then. If they continually try and put it back up under another name or something, that can become like whack-a-mole, but then you can always sue them. And then there is willfulness there, and you can possibly get your attorney's fees back from them if you have a registered trademark. So those are really good facts for you and your attorney if they can get the money from the person who's infringing. What about trade secrets? Trade secrets you have to be very proactive on. So if you have someone that's leaving your employ, you have an exit interview, you take back their work computer, you take back their work phone. They're not taking any files with them. They understand what it is that they were, that they were trained to do in your company, that is your trade secret, that they can't take with them to their next employer. Then you're being proactive. If they're going to a direct competitor in some states, Florida being one of them, and it's inevitable that they'll be disclosing your trade secrets, then potentially you could bring a lawsuit for inevitable trade secret disclosure because they're taking something that is, they were the ones doing it. That was what you trained them to do. And now they're being brought over to this other company to do exactly the same thing. That would be the kind of facts you would need for inevitable disclosure. And then you could stop them from working for that direct competitor in that role. Finally, patents. What can you do for patents? Well, unfortunately, patents are the most expensive both to obtain, to maintain, and to defend. So for patents, most of the time it means sending out a cease and desist letter and suing. And if you send out a cease and desist letter, there are laws in Florida and several other states now that give the other person the right to sue you if you do that in bad faith. So you have to make sure that you have gone through and figured out, done a reasonably objective job at determining that the person you're threatening a lawsuit to has actually infringed one of their products or services has actually infringed or processes have actually infringed your patent, one of the claims, at least one of the claims of your patent. So if you don't do that objectively, which usually means you have to have a law firm that looks at it, a patent attorney at least, that looks at it and determines that the potential infringer is infringing. If you haven't done that, then you shouldn't be sending a cease and desist letter. That costs significant amount of money, maybe $10,000 for starters before you can even send a cease and desist letter. If you send a cease and desist letter without doing that, you could be looking for trouble. But they could claim that you are sending out cease and desist letters in bad faith, and they could get an award of, maybe in Florida, I think it's $70,000 against you. So that is, you have to have attorneys to do that, and that costs money, right? Any intellectual property litigator, any patent litigator is going to charge you thousands or tens of thousands of dollars in order to make that determination for you, depending on how complex it is and how many potential defendants there are. That money can really add up fast. So patents should be only used by a very small minority of businesses, and trade secrets, trademarks, and copyrights should be used routinely by every creative and innovative business to build that hedge of protection around the key intangible property that you have now identified for your company.